Good morning. Good morning. The Rehabilitation and Social Services Committee will come to order. Will the clerk please open the roll so we can determine we have a quorum?
You have a quorum, Madam Chair.
Thank you. I'm going to take a few things out of order, and the first bill we're going to do is actually Delegate Walker's bill because I have members who have to go to another meeting. So this is House Bill 550, and colleagues, I encourage you to put your attention on House Bill 550. Welcome.
Thank you, Madam Chair. So HB, 550 is before you. What this simply does, this bill would grant adoptees that's 18 years of age or older access to their original birth certificate. Obtaining the original birth certificate is a right by any other adults in Virginia except adopted people. Virginia-born adoptees held the right to their own birth certificate since 1976. Currently, the law, the birth certificates are only sealed when an adoption is finalized and well after the birth parents are out of the picture. They are not sealed when a child is relinquished or when the termination of parental rights documents are signed. Birth parents have no choice or say in what happens with the birth certificate if they choose to relinquish their rights. So in short, that's the bill, but we have folks here. If we have some testimony, I'll be grateful to hear from them.
Thank you, Delegate Walker. I will ask my colleagues if they have any questions.
Okay.
Senator Servo.
Delegate Walker, we've done some kind of an assessment to see what the law is in other states to figure out whether we're like outside the norm, in the norm.
I'm sorry, I'm making sure and what you said.
Do you have a sense of what the law is in other states? Out of all 50 states, how many states grant this kind of access? How many prohibit it? Where we stand relative to other states?
So Virginia's been one of these closed states here. You know, once you become an adult, 18 years of age, this is your original birth certificate. And so
Madam Chair.
What is.
Senator Servo, I think that perhaps you didn't understand the question.
Okay, maybe.
May I repeat it, Senator Servo?
Sure, go ahead.
Yes, go ahead.
The question was, how many other states have the practice that you're suggesting in this bill?
Well over 20 or 30 states that we have reviewed. I left a chart up there with you that may have some of that information if you're going through that. But Virginia is still one of those closed states, and that's all we're asking is that we open up so that people can obtain their birth certificate after they become a legal adult, or legal age, excuse me. This was just recently passed in Louisiana a couple of years ago. The legislator spoke to me about that, and so I think at that time there was 20 or 25 states that had already opened up their records. So some of these states are slowly opening up the records for these individuals that can obtain their birth certificate.
Madam Chair.
Senator Servo.
I just did a quick Google search, and what I've been able to see on Google is that 9 states allow what you're asking for. 19 states have it sealed, and I can't figure out what the answer is in the others. Do you have any better information than that?
If I could ask the records office, okay. Would you mind if somebody who has more experience in this, that has been working on this?
Is this an expert witness?
Yes, she's an expert witness.
Okay, you may come to the
Thank you.
podium.
Thank you very much. I'm a little shorter than him, so let me move this. I'm Rebecca Ricardo. I am the Executive Director for C2 Adopt, a local adoption agency here in Richmond. I'm also an adoptee. I'm also a birth mother. And currently, there is 15 states that have unrestricted access to original birth certificates, Georgia being the 15th that has passed half of their legislative session and is about to pass the second half, as they just had crossover. There are other states that have access to original birth certificates, but with some restrictions. So we don't count them in the same way that this bill is being presented. And there are 2 states that have never sealed original birth certificates, and those are Alaska and Kansas.
Senator Servo.
So, I mean, I'm just, in this article that I'm reading, there's all kinds of different ways states have done this. Some states allow parents to file veto petitions. Some states, I guess have other processes in place. Do you have any sense of how many states provide exactly what you are asking for in this bill?
That was my first answer. So it's
9,
14 right
14.
now. 15 will be happening in about 2 weeks.
Okay.
I have a question. What kind of restrictions have the states that walked a pathway where they're balancing the rights of privacy of the birth parents with the rights of the adoptees to know their natural parents? There must be a balance in here. Can you give us an example?
So Louisiana is probably the best example. They just passed this bill 2 years ago. It's unrestricted access with a contact preference form provided at their state registrar's office that a birth parent can complete the contact preference form that simply indicates if they don't wish to be contacted, should their adult adopted child request their original birth certificate, or it can also state, I would actually love to be contacted, and here's how I would like you to do that.
So may I have a follow-up question? If, in fact, they have that contact preference form, is that honored? If the birth parent indicates that they don't want to be contacted?
To our knowledge, we haven't known anyone to make use of the contact preference form in that particular state yet. How it would be honored would be entirely up to the adult adoptee.
So let me just follow up a little bit here. So the birth certificate would be released with the names of the birth parents on the birth certificate, and it would be up to the adoptee to honor the wishes of the biological parent. Is that what you're saying?
Correct, which is already true for any adult adopted person who chooses to engage in a search of their biological parents. If their biological parent says no once they are contacted, it is always up to us to decide to walk away or not walk away. That is already true, and there is no protection right now for search and reunion for adult adopted persons who choose to engage in that, or for birth parents who choose to engage in that. Because in today's age of the internet and of DNA testing, this bill is not about search and reunion. It's about an equal access to the government's verification of someone's birth, that we are a subset of citizens in the Commonwealth who are not allowed access to that document. Documents are not owned by biological parents. Any of you who are parents sitting up there, you don't own your child's birth certificate. You don't get to decide if they see it or not.
Well, we understand the point, but there are issues to balance here. Senator Servo.
It's one of the questions I had. I mean, first of all, I think in terms of some of the questions and the answers is an assumption that both parents are on the birth certificate, and whether or not a father's listed, I think, is the option of the mother. And so,
Correct.
and the mother can put down whatever name she wants. I think there's no testing or anything required to show it's actually the real father or whatever. But given the fact this law has been on the books since 1976, I would assume that a lot of people who were in this situation were thinking about whether or not this document was accessible when they decided to put somebody's name on it or not put it on it, because they were assuming that it was going to be sealed forever. And so how many states have had a situation where records were sealed, then they changed the law and just made open access to things that when people created them thought were going to be sealed forever? Because I think there's also a question of whether you retroactively unseal things or whether you only do it prospectively. How have other states approached that problem? Do you know?
I do know. So Alabama was one of the first states to make this change. That was 24 years ago that they made that change. They have had no issues of any birth parent coming forward and claiming some concern with the state having released an original birth certificate. All the other states that I've previously talked about, the 13, 14 other states, are not seeing any difficulties with the concern that you have. And if I could speak for a moment as a birth parent who has had to make this decision, I assure you the decision of whether my son's birth certificate was going to be sealed or not was not up to me. Nobody asked me if I wanted that. That was what I was told would happen. I didn't want him to not have access to his original birth certificate. My issue of privacy was I was 15 years old. I did not need the general public to know that I was making this decision. I did not need to be protected from my son, and I don't need to be protected from my birth mother. That is not what this is about. This is about being able to have equal access to the government's verification of birth that we are denied as adult adopted persons in the Commonwealth.
Okay,
Madam
thank
Chair.
you. We're not taking comments or opinions just yet.
Madam Chair.
Let's keep this to facts.
Yeah.
Okay, Senator Jordan.
Thank you, Madam Chair. So I'm adopted, so I have a question, and this is very specific. Are you aware that if someone gives birth in the Commonwealth, there is no paternity test that happens in the hospital, so therefore someone could list a father that is not in fact the father? Are you aware of that?
I am aware of that as my
Follow-up question, Madam Chair.
Okay, Senator Jordan.
Thank you, Madam Chair. To that end, that does not change, so that birth certificate will sit 18 years later when that may be opened by this person through this option that may list a person erroneously that may not be the father of a child, which may cause a host of other problems since there's no paternal test at a hospital when a birth certificate is filled out. So you're aware of that.
May I offer a fuller answer to that original question?
Madam Chair, go through the
Madam
chair.
Chair, may I provide a fuller answer to her original question?
Yes.
Because I do work in the realm of adoption and I am frequently at hospitals when children are born, my understanding from hospital staff, as I've watched them take the information down for the original birth certificate, is if the father who is unmarried to the mother is not standing right there giving his agreement to be on that birth certificate, it is left blank. So you are correct, there is no paternity testing happening in hospitals, but they are also not allowing women to put a man's name if he's not standing there giving his permission to have his name put on that certificate.
Madam Chair.
Yes, Jordan.
I'm just going to make a comment to the bill briefly to refute that. Madam Chair, we live in a state that has a ton of military installations, and more often than not, we often have families that are on deployment when birth certificates are filled out. So therefore, this happens probably overwhelmingly in places like Virginia, Florida, and California, where people are added to birth certificates without the father being present because that's common practice, just to make you aware. Thank you, Madam Chair.
Thank you. Delegate Walker, do you have anything further you'd like to add before I take public comment, which I will limit to 5 minutes? I need to say. Oh, my mistake. Yes, Senator Head.
Yeah, Madam Chair, I had several questions for the witness here. So just this is a realm that I don't know, so I'm asking some questions, but some information that I have been given, and I want to make sure that I'm clear on all of this. First of all, just to clarify what you said in difference, and I understand what my colleague Senator Jordan just said about deployment and that sort of thing, but your summation, and Madam Chair, I will have several questions if that's okay.
Sure.
The first question is your understanding is that the situation is that even if there is a deployment, unless that birth mother is married to the father needs to be present in the room for the name to be added to the birth certificate. Is that what you?
That is what I have witnessed as I have been in hospitals with women who are making this decision and needing to fill out the original birth certificate information.
Okay, so it would be nice to be able to verify that, but that's the first question. The second question is there any circumstance today under which the birth mother is able to make the decision to have the birth certificate sealed?
There is not.
And so, Madam Chair, the current situation is that the birth parents have no say into whether or not the birth certificate is sealed, and that decision is made then by whom?
That is correct. Birth parents have no say in the sealing of a birth certificate. The sealing of a birth certificate only occurs once an adoption is finalized, which is many, many, many months later, and only if the adoptive family applies for an amended birth certificate. The state registrar is here today who could probably fully answer that, but only when an amended birth certificate is created does it seal the original birth certificate.
And Madam Chair, one final question here. And so in the event that a child is born and put up for adoption, but then is never adopted, and that's a tragic situation, but it does occasionally happen. If that does happen, is there ever a situation in which those records are sealed?
There is not. And as a matter of fact, if an adoption never occurs, even after a biological parent has terminated their rights voluntarily or involuntarily, the original birth certificate remains the only birth certificate that that person has access to.
And it has all the information that
Correct.
was there. Okay, thank you.
Correct.
Let me add a clarification, and Mr. May, correct me if I misspeak, but my understanding is that an adult adoptee can get access to their birth certificate, although biological parents' names are redacted. They do have information that's related to their health. You know, whatever tests were taken, whatever information shows up on the birth certificate, other than the biological parents' names, they do have access to. Is that correct?
Madam Chair, the current process that an adult adoptee has access to is to file a court order and try to prove good cause to a judge before they can have access to their original birth certificate.
I understand your
Medical
answer.
information is not shared via the state registrar original birth certificate process.
Let me ask our general counsel. The question was directed to Mr. May.
Oh, I'm sorry.
Madam Chair, yeah, so there's two different issues in that question. One is, no, you would not get access to your original birth certificate redacted. You would get access to a new birth certificate that they have issued. The second part about the medical information, that would be things that would likely be included in what the code refers to as your adoption record, which is held by the Department of Social Services. You basically have to file a petition with the Commissioner of Social Services to get access to that information. As an adult, you would be entitled to get non-identifying information from that adoption record, which is what, Madam Chair, you were speaking of, maybe some things that would be helpful to know of for medical reasons, but you would not be able to get identifying information unless the commissioner has found that you've met the good cause standard, which, to my understanding, is hardly ever met.
So there is a way to get access to health information, I guess is at the end of the day. I'm going to take public comment unless, I'm sorry, Senator Van Valkenburg and then Senator Salim.
Thank you, Madam Chair. Madam
Colleagues,
Chair,
please put yourself in the queue so I can see.
my question is more about context, because we're talking about, Senator Serval's questions were about what are states doing right now. We've had some debates about the kind of intricacies of this. I would love to know why the law changed in 1976. I would love the context of that decision, because I think that would be helpful for kind of creating a baseline of the conversation about what we're even talking about, because I'm very conflicted about this bill, but understanding why they made that decision, I think, is maybe helpful. And so maybe that's for counsel, maybe that's for Delegate Walker. I don't think it's for the advocates, no offense.
Delegate Walker, do you have a response?
Yes, Madam Chair. If she could respond to that, I think she has more knowledge of that than I do. And we also have the Office of Records here from the Commonwealth of Virginia that could answer, Senator, if you're comfortable with the questions on the father. He's also here to testify as well, Madam.
Well, let me first turn to General Counsel and then.
Madam Chair, I will be honest, I am not sure. I was not born at that time.
Let the record reflect that's the first time I've heard that answer from David May.
I do know the answer.
Madam Chair, my name is Seth Austin. I'm the State Registrar for the Office of Vital Records. And if it's helpful, I can clarify a little bit about the question that Senator Jordan had and Senator Head had about adding a father to a birth certificate. So in Virginia, the law is that if you're married at any point 10 months prior to the birth of the child, that spouse is automatically named as the father on the birth certificate. Outside of that situation, it does require what's called an acknowledgement of paternity, which can be completed in the hospital if the father is there and signs it. Can also be completed after the fact. But outside of being married, there's no mechanism to automatically add a father.
Senator Van Valkenburg, would you repeat your question about the context? I think that was.
Yeah, Madam Chair, I just don't, my some of my discomfort is not understanding the baseline upon which we're acting, right? And the baseline is that in 1976, we as a state made a conscious decision to change, and I don't understand why we made that decision, but I feel a little bit of anxiety around the state forcing people to do this, and I don't know if that's the right anxiety to have, but I'd love to know why we changed the law, because I think that would be very helpful for people who are on the fence.
And it could have been related to culture or attitudes, so that's right.
Indeed. Madam Chair, I would only be speculating if I
Yeah,
answered
I understand.
that. I don't know the answer.
I understand. Senator Salim.
Thank you, Madam Chair, and this is specifically for Delegate Walker. And as we heard a lot of the comments up here, no one kind of raised the question around privacy. There are reason parents are, making sure that their children get adopted with the confidentiality that the agencies that they go through are going to keep that information, along with government agencies, making sure that restricted access to birth certificate where the names are redacted are in that state. Do you see any unintended consequences with this specific bill where you could potentially see adopted, parents who may get contacted could potentially take legal actions?
I'm not quite, excuse me, Madam Chair. If I may.
Go ahead.
I'm not sure quite how to answer that specifically. All I know is I have the experts here. We're just trying to make available the birth certificates at a point of legal age here. Whether the implications of anything else beyond that, Senator, I do not have that answer I can provide at this point. If that's the question, I understand.
Yes, colleagues, I'm going to take very brief testimony, and I'm going to limit it to 3 minutes because we've had quite a conversation. 3 minutes total, and then we're going to have a motion. So, for those who are present and in favor of this, please come forward.
I did plan to testify. Is that okay for me to go ahead and do that, even though I've already been up here?
I think you've had enough airtime. Thank you.
Okay.
We'll hear from others.
Yeah.
Madam Chair, members of the committee, thank you for the opportunity to speak with you today. My name is Jamie Weiss. However, I was born as Hope Marie in Norfolk, Virginia in 1979. I was surrendered for adoption and finalized 6 months later. My birth mother did not have the choice to seal my birth certificate, as no birth parent has at any time, not now, in the past. That does not exist under the law. It is a common misconception, but it's simply just not true. What led us to this situation of sealing birth certificates really began with a lady named Georgia Tan. I don't know if any of you have ever heard of her. I know we spoke with some people yesterday who had, but she was a terrible woman who stole children and sold them, actually murdered many of them. Some of you may have read books about her and heard about her. This is what began the sealing of birth certificates, because she wanted to cover up her nefarious activities. And it led multiple states to just kind of end up following one another down this path that was horrible and discriminatory against adoptees for no reason whatsoever. Simply, this bill does only one thing. It restores the right of adoptees to their original birth certificate that has the facts of their birth. There is no balancing of rights because there's no one else who is being discriminated against. There's no one else who has a loss of rights here. Only adoptees. This is a good bill with bipartisan support, and it's been vetted through the House. And I would ask for your support today, because restoring this right is essential to ensuring equality for all adult adopted persons that were born in the Commonwealth. It's time to end this 48-year injustice. And I'm asking you to vote yes with no discriminatory amendments on 550. Thank you.
Madam Chair and members of the committee, my name is Patricia Salinger. I became a birth mother when I was 17. I didn't seal the birth record. I had no say in the matter and was not informed when it happened. HB 550 is about equality of access, the right of an adult adopted person to obtain the legal document verifying their birth without going through the lengthy and often humiliating process of getting a court order. I urge your support for HB 550 and allow Virginia to join 15 other states in supporting adult adopted people. Thank you.
Madam Chair and members of the committee, my name is Kelly Layton. I'm an adult adopted person and a registered voter in Arlington County. I'm asking you to vote yes on HB 550 to restore equality to adult adopted persons born in Virginia. Under the current system, adopted persons face a discriminatory policy in which we are denied our original birth certificates. Virginia citizens who are adopted should not be denied the factual record of their birth when all other Virginians can easily access theirs. The current system makes adoptees into second-class citizens by denying us the right to access our own record of our birth. No parent should have jurisdiction over their child's birth certificate. The record of a person's birth should belong to them and them alone. I'm asking you to stand up for equality and vote yes on HB 550.
Senator Servo. Delegate
One
Walker.
last comment, Madam Chair. Senator Servo, I apologize. I didn't read far enough down in my notes when you asked the question about how many other states, so I just want to clear the record. I apologize for not being thorough there in that report. I mean, other than that, I don't have any other questions, Madam Chair.
Okay. I think some of the concerns have already been aired, so we don't have to hear an opposition argument. I think we've heard it. Senator Servo.
Yeah, Madam Chair, so I've just been poking around while we're doing up here, and I found a law review article from 1994, Golden Gate University Law Review, entitled "The Sealed Adoption Records Controversy: Breaking Down the Walls of Secrecy." And at least in this article, it says this trend began in the 1940s, and it was mainly motivated by societal attitudes towards illegitimate children, illegitimate motherhood, or single motherhood, I guess, was the original motivation. I don't know why Virginia did it in 1976, but it's probably about a 50, 60-page article which delves into the complexities of this, which it's very complicated. It talks about different standards different state uses versus consent versus good cause. Some states have a pre-consent statute. It talks about the balancing of the rights of the parents versus the rights of the child and all this stuff. And there's a lot of different issues to balance in this. It's not quite as sort of a unitary choice as I think y'all have made it out to be. I appreciate the view that the child's rights are supreme to the parents. I'm not sure that we have to evaluate it quite that way. But Madam Chair, this just strikes me as a very complicated issue. There's some merit to it. But there's also ways to put our toes in the water to wade into it instead of going 100% all at once. It just seems to me this ought to be studied a little bit more before we try to make a decision on it. So I would move to carry this over to the 2025 session.
Thank you for the motion. And I do want to say, for those who have taken the time to testify, for Delegate Walker and others, this doesn't mean that we are opposed to this idea. This means we're not comfortable yet with the way this bill is presented. There are other ways that we can get to this place. The Louisiana option of sort of a contact preference is something we will look at. If you choose to bring this back next year with a more balanced approach, I think you would find a more welcoming committee. So let me just say that the need for this and the voices before us were heard. Senator Servo's point about it being a complex topic is also very valid. So at this point, we don't have time to make amendments or fix the bill. We're 7 days out from our conclusion, and I believe that continuing this bill is the right motion.
Thank you, Madam Chair and committee members.
Thank you. I did get a second. Will the clerk please open the roll?
Ayes 8, no 6.
Thank you. Okay, colleagues, we have a busy agenda. The next, I can't remember who came first, but the next one up here is Delegate Helmer. Delegate Helmer, your bill is very straightforward.
Well, Madam Chair, in that case, members of the committee, all this bill does is say that if the federal government doesn't require you to appear in person for WIC, we're not going to do that. I appreciate all the help of DSS and others in crafting this, and ready to take any questions you may have, Madam Chair.
Colleagues, do you have any questions? It just prohibits the Board of Social Services from requiring persons applying to show up in person, and I believe that's also the federal reg. The federal regulation does not permit a prohibition on showing up in person either. Is that my understanding?
Madam Chair, my understanding is, for the most part, we are codifying existing practice. DSS has worked closely with us. I think the difference is there are states, and Virginia has at times done this, that will require in-person there's follow-up meetings, things like that, as you continue to qualify for SNAP benefits. And so what this says is we moved to a posture after the pandemic where we did more televisits and Zoom and things like this. This just allow us to continue that.
The key word is requiring. We can request or do. Okay.
Absolutely.
Colleagues, the bill is before us. There's no fiscal impact. It seems to be a very friendly bill towards our most vulnerable who are eligible for these services. May I have a motion? Okay, is there a second? Okay, clerk, please open the roll.
Ayes 8, no 6.
Your bill reports.
Thank you.
Okay, next in the queue is, well, the next one I see, Delegate Hernandez.
Good morning, and thank you, Madam Chair, members of the committee. This is HB 855. This is a simple bill designed to help DSS move more quickly to establish a year-round application window for the low-income heating and assistance program known as LIHEAP. Just by way of quick background, LIHEAP is a federally funded state-administered program to help Virginia families pay their energy bills. The problem has been that the application window is exceedingly brief. So, for example, the time to apply for heating assistance under current law is just a few weeks, and that application window is misaligned when most people need help the most. The result is that the federal dollars that Virginia receives for LIHEAP are underutilized. In fiscal year 2021, the program only served about 30% of all families who are eligible for assistance. So this bill just helps them go to a year-round application process. DSS wants to do this. We've worked with them on this legislation. And my understanding is that with the text before you, they'd be able to complete this regulatory process by the end of this year or thereabouts. Without it, it could take much, much longer, several more years. So that's the bill. Hope it will be the will of the committee to support it.
Yes, it's a very straightforward bill. I will say Finance has asked for this. I guess there's an issue that if we allow which, by the way, I philosophically agree with you, if we expand the application process, more staff need to be hired. I think that's the issue behind this, but we're also leaving federal money on the table.
Right.
So I will take a motion on this. Okay.
Second.
Thank you. A motion has been made to report and re-refer this bill to Finance. Clerk, please open the roll.
Ayes 14, no 0.
Ayes 14, no 0. Okay.
Thank you to the committee.
Let's see. Delegate Tran. Colleagues, let's turn our attention to House Bill 992.
Good morning, Madam Chairwoman and members of the committee. I do have an amendment that we worked with council on developing.
Okay. Could you read the amendment? Is it a line amendment or is it amendment in the nature of a substitute?
Madam Chair, it's just one line amendment on line 16. After services, period, and the first bracket, strike no, insert except as required by federal law, comma, no. So it's just putting in an exception as to the extent that we're permitted to do this under federal law, basically.
Okay, may I have a motion to accept the line amendment? All those in favor signify by saying aye. Aye. Okay, the amended bill is before us.
Great, thank you so much. And that amendment came during our conversations with the Department of Social Services, just to be clear that federal law still supersedes what's in this bill. This bill is a recommendation from JLARC's self-sufficiency programs and the availability and affordability of child care study recently. And what it does is just directs local workforce development boards and the departments of social services at the local level to develop and enter into a written agreement to coordinate services for SNAP employment and training participants and the TANF-VIEW program participants. Helps to make sure that our Virginians who are in these programs are getting all the different employment and training services that are offered to make sure that they're able to be on a path to self-sufficiency.
Okay, and this is a Section 1 bill, and it is asking the local departments to enter into a written agreement with the local workforce development board. So I would think this is something they should be doing anyway.
That's right, ma'am.
Is Mr. Ayers here? Do you have any comments on this bill?
Good morning, Madam Chair. Carl Ayers, Deputy Commissioner of DSS. So as the delegate mentioned, there was a question with the amendment that came through that didn't want to put us out of context with the federal law from that. So the amendment this morning, I think, fixes the issue that had come up and has arisen. So we completely agree with the JLARC recommendation to work on these agreements and ensure that all of our local departments have the agreements in place. As far as the bill goes, we don't have a position on the bill, but it is something we worked with JLARC on and have worked with the delegate to make sure I can implement the bill if it goes forward.
Again, I think this is a very straightforward bill. Thank you. Motion has been made to report the bill as amended, and it was seconded. Will the clerk please?
Yeah, Madam Chair.
Yep,
Just,
Senator
I
Head.
just had a question because I'm a little confused with this. I love the idea of the plan. I really do. And the amendment that you just put in to keep us from being out of phase with federal law, I appreciate that. The question is that parenthetical in this thing from the end of line 16 to the end of the bill appears to be giving an out to someone if we say we've got this program and in order for you to get benefits, we want you to be in this program, and if you just choose not to, well, too bad. And that sort of, to me, defeats the purpose of the bill. And can you help me wrap my head around that?
Yes, Madam Chair, Senator Head, the exact issue that you raised came up from the AG's office in the review of the amendments. So the amendment that was offered this morning, the AG's office and their counsel to us feels like that fixes the exact issue you brought up. Is that, sorry.
Yeah, Madam Chair, again, I understand what it's fixing, Madam Chair, that it's what it's fixing is we've got to keep it in phase with federal law, and the federal law says you must do this. But absent that, we might be able to lay something as an additional requirement, or would that put us out of phase as well? If we put an additional requirement over and above what federal requirements were, would that put us also out of phase with federal requirements? And so is that the reason that AG office had the same?
So,
I don't know if I'm articulating the question the right way, but I just want to make sure because if that really does fix it, then I'm actually I was inclined to not support the bill, and now I think I like this a lot. Yeah. So,
Mr. Ayers, thank you for the question, Senator.
Yes, Madam Chair and Senator Head, we can never be more restrictive than what the federal government is in a program. That's how I understood. So I think that answers your question.
Thank you. And thank you, colleagues. I have to remind you to get yourself in the queue because otherwise I'm not going to see you unless you're, piping up. So please get yourself in the queue if you want to speak. Okay, a motion has been made and seconded to report the bill with the amendment. Will the clerk open the roll?
Ayes 14, no 0.
Thank you so much, Madam Chairwoman and members.
Thank you. Okay, Delegate Shin.
Good morning, Madam Chair.
And the next bill will be House Bill 606, but I don't see Delegate Price here. Delegate Shin, go ahead.
Thank you. Excuse Excuse me. Thank you, Madam Chair, and good morning, members. House Bill 913 is before you. House Bill 913 just ensures that if the Virginia Parole Board requires 4 members in order to issue a parole ruling, but that there are not 4 members on the board, a unanimous decision of the existing board will satisfy the requirement. And the reason we're doing this is because for the past couple of years, the parole board has had some vacancies and they have thus been unable to conduct their business. And really the intent of the bill is to ensure that our parole board, like any other government body or agency, is able to fulfill their duties, even if there are other weird things happening like vacancies on the board that last for months, if not years.
I have a question. Okay, the last line, then the requirement shall be satisfied upon unanimous vote of the members on the parole board. Are we implying that there has to be a quorum? Because I would feel more comfortable if it said such requirement shall be satisfied upon unanimous vote of the members constituting a quorum on the parole board. And that's, unless that's already expected or stated. Maybe David May can answer that question for me.
Could I? Oh, we actually went back and forth with, not you, Mr. May, but council or DLS staff on this before too, because we were wondering the same thing during the drafting process of this. And I think where we landed was that if there are 3 members, then quorum would be having 2 members. And so instead of, I think we did go through back and forth on this, and we landed in this specific place because we thought that it wasn't necessary. But maybe Mr. May has a different opinion. I'd be open to hearing it.
Let me hear.
Sure.
So, Mr. May, upon unanimous vote of the members, so can they not have a meeting unless there's a quorum? Are we talking about a quorum being present? I think that's a reasonable question.
Yeah, Madam Chair. So kind of a tricky question because unsurprisingly, the code is not very clear on votes by the parole board. And I think because of that, the parole board has taken it upon itself to come up with its own rules. One of those rules is the rule that Delegate Shin is trying to fix. Another one of the parole board's rules says that basically they have to have at least 3 votes, which is a majority of the 5 members, to grant parole or conditional release. In certain cases, there's a couple of cases where they actually require upon themselves, again, internal rule, 4 votes. In cases where they've identified a need for more votes or additional look before they're granting parole to this particular person for certain offenses. So under the language of this bill, right now, if we're assuming that the Virginia Parole Board's rules stay the same, they would have to have 3 votes to grant. Okay. If they no longer have that rule, and then we have this law in the books, it would just be the unanimous vote of however many members they had.
I think I'd be more comfortable articulating that we have that there must be a quorum there. Would you accept that as a friendly amendment?
I would, Senator Favola, but or Madam Chair, I wonder again about how does quorum get qualified? So if you have 3 members of the board because there are still 2 vacancies, then would all 3 members be considered quorum?
Good question. Let's ask. Good question. Let's ask David May, because she's right. There are vacancies.
Madam Chair, yeah, that's part of the difficulty of the code not being clear on this point. To answer the question briefly, we don't really know, as far as just looking at the code, what the answer to that would be. I would say there's a couple opportunities or a couple ways that we could amend the bill if that was the will of the committee to require. I mean, we could just put a hard number in basically, and we could be very clear. If we want to have 3 votes, then you put 3 votes, and then we don't have to worry about how that's interpreted.
But they have 2. But a quorum is 3 out of 5. But do they currently have 2 vacancies?
No, I think we don't have vacancies right now, but there were for quite a while.
So my understanding is there are 5 members, and so 3 out of 5 would be a quorum. Is that correct?
Madam Chair, Madam Chair, is quorum? What's quorum in the I wasn't paying attention. What's quorum in the code? Is it a specific number or is it a percentage?
It's the same. If there's 5 members, it's 3. If there's 4, it's 3.
Mr. May. Mr. May.
Normally, when we have these boards or any sort of commission set up, we specify exactly what a quorum is because we change those provisions from time to time, depending on what it is. In this particular case, we have no provisions.
We have no provision in this. So we can either put no less than 4 members on the parole board, then such requirement shall be satisfied upon a unanimous vote of the members. I would say consisting of at least 3 members at the meeting is what I would say. But that's my preference. Where are you, colleagues? I can go either way. Senator Head.
Yeah, well, Madam Chair, my question is if a quorum is 3, if there are vacancies, does that still require 3 to constitute a quorum? And because if it does, then this is fine as it is, I think. But I mean, if the absence of members changes because now you've only got 3 members on the board, does that change the amount of what a quorum is for them to be able to even hold a meeting? And if they
I think that's all unclear. Is
yeah,
what I'm hearing.
We got to nail this down. If it's unclear, we need to make it clear. So,
Mr. May, do you have any suggestions hearing this conversation?
Madam Chair, let's assume if the board was set up like every other board, the code would likely say a quorum is 3 members, and you have to have a majority of members, which would also be 3 for any vote to go through. So if we want to make sure that at least not only is it unanimous, but you got at least 3 votes, like it doesn't go down to 2 people, then we should just put what you were suggesting, that it shall be no less than 3 members.
I would say no less. Can you accept that as a
No, Madam Chair, I appreciate you. Thank you.
Let's take a motion on this amended bill. Okay, motion is before us to report with the amendment. Will the clerk open the roll?
Ayes 14, no 0.
Thank you, Madam Chair, members.
Okay, I'm going to have staff present Delegate Sigel's bill, and then we're going to go to Delegate Price's bill, which will have a more lively conversation. So here's Delegate Sigel's. He came right on time.
Sorry, I'm late.
Okay.
This is not my first meeting this morning. I just want you to know. Senator Rouse can vouch for that. Okay, you got to figure out what this is. Madam Chair, Madam Chair, I think that you guys have an amendment, I heard, that's possible. No. Okay. 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 This bill, Madam Chair, members of the committee, updates our ADA policy to try to make Virginia law, or to make Virginia law consistent with the federal law on this score, and it is brought to us by the Disability Law Commission, and the language in here is the current language that's used in this area that employers have to do. What is the term here? I'm sorry, I thought I'd be able to sit here for a minute. To make readily achievable is the key term. Each place of public accommodation shall ensure that barriers to accessibility are removed when the removal is readily achievable. I think readily achievable is the term of art now that's used, and then there's a list of things that kind of define whether readily achievable is in fact the case or not.
So there's nothing, if you read the existing code that stays on line 99, it says nothing in this title shall be construed to require retrofitting of any public transit equipment or to require retrofitting, renovation, or alteration of buildings or places to a degree more stringent than that required by the applicable building code in effect at the time the building permit for such building or place is issued. So, you know, it's
forward is,
yep.
We have to follow this anyways, and you're codifying it. I mean, okay, it must have been your compelling presentation, Delegate Sickles. A motion has been made and seconded to report the bill. Please open.
I mean, several people have said I should have been a lawyer, but you know,
You may be doing better without that title. Will the clerk please open the roll?
Thank you, Madam Chair, members of the committee.
Okay.
Ayes 14, no 0.
Thank you. Okay, the last item is House Bill 606. Oh, my apologies, I didn't see you. Delegate Price.
I just got here. Thank you. Yes, Madam Chair and Senators, currently in Virginia, the Board of Social Work requires social workers to pass the Association of Social Work Boards exams in order to be licensed. These exams can range in cost between $230 and $260, with the vast majority of social workers seeking clinical licensure investing over $5,000 to obtain supervision hours. There is severe and urgent consternation about the exam and pass rates and disparities within marginalized communities, especially with language justice for those where English is not their first language. This is creating a huge obstacle from having licensed social workers that reflect the communities they serve. And so the exam is described as a tool to, quote, test a social worker's competence to practice ethically and safely. And we really believe that actual experience can often test that competence even better. We have some quotes from some folks that have taken the exam, and one is talking about how they're repeatedly tricked questions and they were told to focus on test-taking skills and practicing the process of elimination as opposed to their actual clinical and ethical knowledge. And so despite Kristen having over 3 years of practice and experience, she only passed with like 10 points above failing. And so House Bill 606 is understanding that we are in a crisis and a shortage with our social workers. So it would direct the board to create an alternative pathway to licensure for the licensure of clinical social workers to include an additional 1,500 hours of supervised clinical experience within a 5-year period. And I was talking with some of the social workers I've been working with, and that it can probably actually take an additional 2 years. So giving up 2 more years of your life instead of getting, I guess, stumbled upon on these trick questions, we think would be a great way in order to get really wonderful people into this noble profession, especially as we're experiencing quite the shortage.
Thank you. I have heard from stakeholders on both sides of this, so we will take public comment, no more than 3 minutes on each side. So for those who are in favor of the bill, please come forward. And then we'll probably have questions from my colleagues. I have 3 online. It's 3 minutes total. So if the people in person use the 3 minutes, then we won't be taking virtual. So you can go ahead. Colleagues, I ask you to draw your attention to our speakers. Go ahead. This is in favor of the bill.
Yes, Madam Chair. Good morning.
Go ahead.
Stephanie Showalter on behalf of the Virginia chapter of the National Association of Social Workers. HB 606 is a top priority for NSAWVA. Virginia is currently not only in a workforce shortage, but a mental health crisis. An exam alternative is one of many tools we must utilize to address both of these issues. There's evidence that indicates the examination may be a barrier for some test takers. For those test takers who are unable to pass the exam on their first attempt, the examination registration fee can pose another barrier to retesting. The examination alternative is not intended to be an easier or quicker route, just an alternative for the skilled and competent social workers who are unable to join our workforce due to these barriers. NSAW urges the committee to support this bill. Thanks.
Good morning, Chair, member of the committee. My name is Abby Phillips. I'm here in my personal capacity this morning as a social worker. In 2022, the Virginia General Assembly asked the Virginia Health Workforce Development Authority to look at clinical and healthcare workforce strategies or shortages, and they found that though Virginia ranks 12th in the nation for population, we're actually 37th for the number of licensed social workers that specialize in mental and behavioral health. HB 606 will help support and attract more graduated social workers in obtaining clinical licensure in Virginia, not by lowering the standards, but by creating an alternative path where they would have to complete an additional 1,500 hours of supervised experience. This will help qualified and competent behavioral health practitioners to obtain their clinical licensure and get to the communities to support and guide them on their healing journeys. Thank you.
Good morning. My name is Lily Hetrick. I'm a current Master's of Social Work student at Virginia Commonwealth University, and for all the reasons just stated, I support this bill.
Good morning. My name is Ailsa McCutcheon. I am also a social worker, and I believe that the values that this bill upholds are also social work values. Thank you very much.
My name is Margot Weitzel Brim, and I'm a current Master's of Social Work student at Commonwealth University. Passing this legislation would bring the Commonwealth one step closer to filling the huge need for licensed professionals with relevant lived experience. And for this reason, I support the bill. Thank you.
Madam Chair, members of the committee, excuse
We're
me.
full committee.
Kat Atkinson, both with Voices for Virginia's Children, and I am a social worker. And we are in support of this bill for all the reasons stated. And we need more people who look like me in the work. And this is the way to do that.
Okay. For those who oppose the bill, we still have a little time left. Excuse me, before I get to the opposition, go ahead, pull them in on the virtual platform.
Fatima Smith and then Kristen.
Would you please just state your name and your organization or that you support the bill?
Fatima and I'm a chair and I support the bill.
Okay, and the next person on virtual?
Madam Chair, members of the committee, my name is Kristen Lennox. I'm in support of Social Workers for Change. I support HB 606.
Thank you. And is there one more on the virtual platform? Okay, so those in opposition to the bill, please come forward.
Distinguished members of the committee, my name is Dr. Stacey Hardy Chandler, and I'm proud to come before you as a clinical social worker licensed here in Virginia and as the Chief Executive Officer of the Association of Social Work Boards, headquartered here in the Commonwealth. I'd like to start certainly by expressing my gratitude to Delegate Price for the time she spent with us in conversation. We certainly agree that workforce is the right topic, but this exam is the wrong target. ASWB, like other professional healthcare associations like medicine, nursing, physical therapy, pharmacy, shepherds the administration of the licensing examinations and provides boards with an array of other resources and services to relieve some of their governmental burdens. It is because of the integrity of our work and the work of practicing social workers and educators who contribute to the exam that I am here today in opposition of HB 606. ASWB is the only nonprofit organization dedicated to serving the social worker regulatory community. As with other healthcare regulatory associations, our mission is about accountability and assuring the public's trust and confidence through the promotion of professional standards. ASWB's concerns about the option to issue a license without the requirement of passing a licensing exam for social work alone and no other profession, as permitted by this legislation, we cannot support provisions that create basically a two-tiered system for the exact same category of practice. This would have significant detrimental impacts for our profession for two critical reasons. First, it muddies what the public is entitled to when they expect to work with someone with the title of licensed clinical social worker. We owe the public consistency and clarity. Second, the most disturbing concern is that people of color will be overrepresented in the alternative tier of clinical licensure, as this has been explicitly promoted as the core rationale for putting this bill forth, and will perpetuate the very disadvantages the bill proposes to remedy. The bill and bills like it fail to contemplate social workers in the military, those working in federal roles like with the Veterans Administration, and those wanting to pursue licensure through the multi-state compact. Workforce is the right topic. Exam is the wrong target, but we welcome on this first day of Social Work Month the opportunity to work collaboratively across the profession to address real root causes of the social work pass rate disparities. Thank you.
Thank you. We'll take one online, and that will probably conclude our conversation with the public. And then, go ahead.
Shelley McDowell Porter, you may begin.
Thank you. Good morning, esteemed members of Congress. My name is Dr. Shelley McDowell Porter. I am representing myself. I reside in Maryland. I'm a licensed clinical social worker and an industrial organizational psychologist, as well as a certified diversity professional and academician. Throughout my career, I've dedicated myself to serving individuals, families, groups, organizations, and communities across multiple social work settings and practices, and always with the effort of systemic change efforts. Over the last 20 years, I've worked half that time as a military social worker, and being a licensed clinical professional has allowed me to take advantage of working in multiple states. That experience to support the service members and their loved ones were extremely foundational to my career. The latter half of my career, I've spent working within the social work sector, but also as an industrial organizational psychologist, doing psychometric work for assessments and credentialing, working as an analyst, researcher, and consultant for both the intelligence community, the government, and academic and private institutions. As a part of my role, I've been intimately involved at every step of the exam development process, from conceptualization to data analysis. So I know what valid and reliable data looks like. However, I also understand that there is a discrepancy in the pass rates, especially for persons of color, women, older adults, and persons with disabilities. And so it is a concern for me, but I've seen ASWB take commendable steps in transparency. For example, putting out their data results.
Ma'am, I'm going to have to ask you to conclude. I had allowed 3 minutes or a little over for the pro side, and now we're just about, we're a little over for those who are in opposition. So if you could just conclude your position, that would be great.
Understood. Thank you, ma'am. In conclusion, I support ASWB in the processes that they're taking and don't support this current bill. Thank you very much for your time.
Thank you. Okay, colleagues, the bill is before us, and Delegate Price, do you have any concluding remarks?
No, just I've been working within the mental and behavioral health area legislatively, and every single meeting we're talking about, we don't have enough people, we don't have enough people, we don't have enough people. And so I'm really glad to be here with the social workers and trying to fight to get more of the good people we need into this workforce.
Okay. Motion has been made and seconded. Is there conversation over here? Senator Head and then Senator Reeves.
Yeah, Madam Chair, I have just some concerns with this, because as I read through the bill, and I understand we're needing to do this, but we're taking something that is a measurable standard, and I think perhaps maybe the test needs to get examined to see, because if you've got a test and again, multiple choice tests that are just, if you're gearing somebody up for test taking, that may not be the best metric, but at least it is a metric. And while you've got 1,500 hours of supervision, I don't see that being defined and having any kind of reliable metric that would absolutely demonstrate with confidence the competence that's going to be required to be a licensed social worker, and I'm real concerned about that. And just as further question on this, do I remember that we have had a bill talking about an interstate compact for social workers? We've already dealt with that, right? I'm very concerned if we start changing that's a path to get to help open the door for more people. I think this would very likely just completely upset that apple cart and make us not qualified, because it's going to change our positions on that. So.
Madam Chair, I would answer there. As the chair of the Health Professions Subcommittee, we did have a bill that came before us, and so I talked very intently with DLS staff, and we went through, and it's not in conflict. You would actually have your licensure and not be eligible for the compact, but it would not negate Virginia being able to be in the compact. And honestly, there haven't even been enough states to sign up for that compact to be in place yet. So this isn't the counseling one. We are not officially in the compact, but we have gotten confirmation that there can exist this alternative exam structure and the compact at the same time.
Madam Chair.
Okay,
Madam Chair.
I have Senator Reeves, and then it's going to be Senator French, and then Senator Van Valkenburg, Senator Saline, and I guess Senator Carol Floyd. We all have a lot to say. Senator Reeves.
Thank you, Madam Chair. Delegate Price, I understand what you're getting at, but I want to throw a personal example to you. You know, I think I'm the only one on the dais that's been a police officer, and I can only think that this is somewhat, we're short of police officers, so maybe we should just put them on the street, put a gun in their hand and let them enforce the law that they haven't been tested for. So throughout that process, you go through exam to test your competency throughout. In all my other areas of life, I've had to take these exams that just suck. And they're grinding, whether it be for a master's degree, for a financial Series 6, 63, and 7 in the financial services, life and health, property and casualty licenses. They're just a grind. And they are an impediment to some people being able to be in that profession. But I got to agree with my colleague. I don't know if we need to look at the test to make sure it directly gets at why the fail rate is so high, or are we not teaching those competencies ahead of time through our educational institutions? I've heard from witnesses that are attaining their masters and looking at that curriculum. So as much as I'd like to vote for it, I don't think this is the correct solution to the issue that I think you're trying to address. So I'm going to be a no today.
Madam Chair, I would just say I appreciate analogies. I do think that's an apples to oranges comparison, and I just want to make very clear, this is not about making the process easier because the test is hard. This is about trying to get at a process that can correctly and I think appropriately measure someone's ability to do the job. And so 1,500 hours is not a small thing. And so for anybody that might have heard me say, we're trying to make it easier, that's not the thing. It's just there are existing some disparities and the implications of some of those disparities. This is a tricky conversation because if it's not the test, then there are some implications that I think are being offered that we really might have to kind of sit with as a body. But this is offering an alternative pathway for people to be able to get in there. So I just wanted to clarify that if I in any way led you to believe that this was trying to make it easier because the test was too hard, that's not necessarily the point that I was trying to make. So I appreciate your comments.
I understand. Senator French, you're in the queue. And then Senator Van Valkenburg and Senator Slee.
Thank you, Madam Chair. I just want to say that I feel like this bill to me is where work experience would go and allow someone to move forward. And I just don't know that 37 and a half weeks at 40 hours a week is enough on-job training to forego the exam. So for those reasons, I'll be voting no.
Senator Van Valkenburg, Senator Salim, and Senator Carol Floyd, at one point you had your name in. Okay, it was removed here, but go ahead, Senator Van Valkenburg.
Thank you, Madam Chair. First, a question, and then a follow up with.
Sure.
So the question is to Delegate Price is the concern I think that would most concern me about the opposition side is that they talk about the disparity, like then you might not be able to work within these federal jobs. But to clarify, would you still be able to take the test at a later date if you wanted to apply for those jobs? Yes. Okay. Then secondly is I share anxiety around how we measure how we measure capability, and I tend to be probably more protesting than most of my friends on my side of the aisle for that reason. But I do think that we can have multiple measures of success, right? And we just have to do it thoughtfully, right? And I disagree with my colleague about 1,500 hours. That's a lot of hours, especially when it's built on top of the already existing ones. I wonder if you would be open though, because I think to Senator Reeves's point, maybe, right? Like when we create these alternative measures, we do want to have some kind of an objective standard that says, okay, well, you did this other route, and this other route shows that you're successful. And so I wonder if, and David May, I'm getting you into this conversation. I'm wondering if you would be open to an amendment that would kind of explicitly say that upon the completion of those 1,500 hours, that licensure would be dependent on their the person that they're under signing off that they're capable. I don't know what that language is, but maybe this is an amendment in concept, as a way of saying, hey, it's not just that you complete the 1,500 hours, right? Because maybe you complete the 1,500 hours and at the end of it, you're still, hey, this is not for you, right? But if they sign off at the end of that 1,500 hours, somebody who's already licensed it says, hey, this person is capable, right? Because I think the more apt comparison is not the cop, and maybe it's not the teacher, but it's somebody that's in a field where you're interacting with people, and it is a little bit of an art, right? So I wonder if that would be considered a friendly amendment.
So would you accept that as a friendly
Madam Chair,
amendment?
I absolutely would, because again, it's not about lowering standards, it's about creating an alternative.
No, I think the conversation is about ensuring that
I'm in
standards
agreement.
were the 1,500 hours and the quality of those hours
absolutely
are good.
So
colleagues, let's hear the amendment from our general counsel, Mr. May.
Madam Chair and Senator Valkenburg, is the intent to just have them verify that the hours were complete? Because I would say there is a requirement in here already that says the board's examination alternative has to be sufficient enough, because we're telling them to make regulations, and part of the regulations were it's got to be sufficient enough to be able to ascertain their qualifications and their fitness, right? So we don't even know what that's exactly going to look like yet. The board is going to put that in their regulations. We just told them it needs to be sufficient enough to ensure that. So are we trying to get them to verify the hours, or are we trying to get them to also say we think these are 1,500 quality hours?
Madam Chair, not just to verify the hours, but to maybe to say that when the regulations are promulgated, there has to be that kind of back end. The licensed professional agrees that they have met that criteria, which is probably something they would do anyway, but like just to codify it to ensure that it happens.
The licensure would meet certain professional standards, if you will, in addition to the 15 hours. I think.
Essentially, the licensed professional would be staking their professionalism, right, on saying that this person has met the standards that I follow.
I think actually that would be the only way I could vote for this, to be honest.
Madam Chair,
I have other people in the queue, Senator Salim and then Senator Carol Foy, and then we're going to conclude this.
Madam Chair, should we hear the amendment first from counsel?
I think he's working on it.
Okay, come back to it.
Senator Salim and then Senator Carol Foy.
Thank you, Madam Chair. I think Senator Van Valkenburg sort of mentioned my concerns. And again, I do appreciate Delegate Price for bringing this up. There are certain professions where you will see a lot of people with maybe 6, 7 certificates after their name. And I'm just being frankly honest in my profession, and half of those people do not know what they're doing. Whereas some of the folks who have been in that field for decades with the experience, they are aware of exactly what's going on, but they don't have that professional license that's required, not because they're not able to obtain that. It's just, whether it's, they took the exam and they didn't pass it, or it's a 3-part exam where in between each exam you have about 2 months to complete the next phase. So I think you are, bringing this bill, it's not just looking at the specific field, it's giving other folks the opportunity to look at other examinations as well. But again, I do believe we are providing an alternative way for someone to succeed who's been in the field. And again, with the amendment from, friendly amendment from Senator Van Valkenburg, I think this needs to be moved forward.
Senator Carol Foy, and then we're going to ask Mr. May to read the amendment so we have some sense, and then I will call on you.
Thank you, Madam Chair. Speaking to the bill. I'm speaking
Go ahead.
to the bill.
You've got the.
So first, I'd like to thank the patron for bringing this. I can tell you that probably without the alternative, I probably would be on the fence about supporting. So I'm glad to hear that there is one. But let's be clear. Historically, standardized tests have resulted in racial disparities. And, you know, it's going to take a holistic, separate approach to address that. But you have it in a litany of standardized tests that people have to take. It's typically used as a filtering tool. But here, we're removing a barrier without compromising standards. And we are replacing testing with experience. And with the amendments from the senator, I think it's going to be even something more that a person has to do to say, I've met these necessary requirements. And as you said, I just want to make sure that everyone heard this alternative to testing, and this is actually analogous to teachers, because I actually carried a bill a couple years ago that created an alternative to the praxis for people who continue to fail because of the racial disparities that you had in the praxis. And we're trying to attract and retain top talented teachers of color, and that actually is a way to address that. So I know someone said, well, this is an analogous to teachers. It actually is. And we actually passed a bill that does just this for teachers. So I want to thank the patron, and I hope everyone can support.
Let's hear the amendment, because I think that gets this to a place where we're more comfortable. Mr. May?
Okay. This is what I've come up with. I appreciate if we do it in concert because I've got to tighten this up a little bit. But the amendment would be on line 18 after licensure. So right at the end of the sentence, we would add language saying, and the person under which such supervised experience was completed shall have attested to the applicant's completion of 1,500 hours of supervised experience and attest to the applicant's qualification and fitness to serve as a clinical social worker.
That's perfect. Go ahead.
Thank you, Madam Chair. I can't help but think about of another occupation that I think maybe not at the same equivalency, just due to the licensing part of it, but I've taken the LSAT 3-4 times. Never made it all the way up to the top, but I did get into law school. And that's an exam that tests your aptitude, whether or not they think you could pass law school. But there are some of my colleagues that were police officers that knew the law, the 46.2 and 18 whatever it is, code section, and I think could be competent attorneys. So it falls into your same logic. But ultimately, they would still have to pass the bar. There's a process to where they could read under an attorney, do about, I think it's 3,000 hours, if I remember right, but they would still have to take the bar. So while I like Senator Van Valkenburg's idea, we have to do that in law enforcement. When we graduate the academy, we still have hours upon hours where we have to ride with a senior officer till we're released through a field training officer. And we still have to take an exam after that. So I think there has to be some metrics of measures to test the competency. I understand that another colleague can say, he's passed, he's good to go, or she's good to go, but I think there has to be some measurable exam to show the competency.
Let's just be clear, though. This is a pathway so they can practice their social work. And if they want all the venues that are open for social workers, such as federal venues and others, then they would be taking the exam. So there's nothing here that precludes them from taking the exam. This is sort of it could be an interim step for many social workers. Senator Craig.
Yes, thank you. So once they do their 1,500 hours and now with the amendment, someone would sign off. What happens if I say I can't sign off on you, I don't think you're ready? What then happens?
Madam
None.
Chair, I would say, based off what I'm seeing in the amendment, then you have not fully qualified for this alternative process.
Then you would have to take the exam.
Or not practice as a social worker.
Or not be licensed.
So there, we are putting a safety net or quality safety net into this. And if this motion does pass, I think, if you don't mind, colleagues, I would like to write a letter as chair of the committee asking the Board of Social Workers to really, ask the Board of Social Workers to evaluate the test and to identify strategies going forward where the test is perhaps much less biased and yes, go ahead.
Yeah, just
Senator Craig.
So I like Senator Reeves, I was in the police academy. We had to, go through classes every day and then benchmarks, and then we also did a test at the end of the 24 weeks, but we also then had a verbal test where you go into a room and they just shoot off questions at you with 6 people, and you got to think quick on your feet. Would a verbal test, I mean, if a written test is not, maybe you don't think a written test is conducive, could they do a verbal, like a verbal interview and questions that way, so they could then still at least, it would show that they're knowledgeable of all of this?
So, Madam Chair, I would say that would actually be a little bit outside of the scope of what we're trying to do with this bill, and that would actually be, I guess, up to the Association of the Social Work Board, as they, have said that they are continuing to evaluate the test. They might be able to take that under consideration for what they're saying, but I would not say that the oral exam would. Say, not trying to be funny, but if the test is problematic, saying it out loud or writing it down, to me, it doesn't necessarily fix the problem.
Well, I just want to remind colleagues that under this bill, the Board of Social Work will amend its regulations for this alternative pathway. So in those regulations, I tend to agree, sometimes a verbal face-to-face where you can read bodily cues or be given the opportunity to present an experience might be helpful. We have to conclude this. You have really given us something to think about. A motion is before us to report the bill as amended. Oh, no, we don't have the motion yet.
Madam Chair, I'll let the committee decide on this, but there may be one other just technical sort of amendment on line 18, where it says that the conditioner is that you've actually taken the test, right? So it says an applicant who has taken but has not successfully completed. I think it should probably say has taken but has not passed. I don't think actually completing the test has anything to do with it.
That's a good catch. Second? Is there a second? All right, all those in favor of this amendment signify by saying aye. Aye. Okay, I think staff reminded me I don't have a motion. May I have a motion to report the bill as amended? And there's a second. Okay, will the clerk open the roll?
Ayes 6, noes 8.
Thank you, Madam Chair.
Okay, colleagues, what we'll have to do is, with your concurrence, I'd like to write a letter to the Board of Social Work asking them to evaluate the issues that came up, and I'm still going to ask them to consider an alternative route. I don't think this conversation is over. We've got next session. This is not going away, and perhaps we'll be able to get more unity with all the stakeholders. Before we conclude, I do want to take a moment to thank our very able staff who supported us this past year. Jillian Conway, who's been our clerk. Alexander Chapman is an intern in the Senate Clerk's office, and David May has been providing legal counsel. Thank you. You've been wonderful. Could not do it without you. There's no further business to come before the committee, and the committee shall rise.
Virginia, Richmond, Virginia.